Yeah.
What am I getting today? It's too small, my but it's always like just way small. No macchiato. Maybe a final reference. I didn't get the last one when we talked about the
Però io credo che i valori universitari io
So the last time we met, there were a few things we didn't touch on, which I'd just like to conclude. and then move on to what we're dealing with today, which is about legal rules on the raising of capital. If you remember, we talked about the terminology. We talked about the terminology of capital. I hope you can see that. And I said to you that it's important to sort of be clear about how the term is being used. Usually, when businessmen talk about capital, they don't refer to the ideas that we're concerned with. They're usually concerned with net cash flow. So they're looking at basically the cash flow position of the company when they talk about capital, because obviously cash flow is the lifeblood of the company. Whereas from a legal perspective, when we talk about capital, I suppose it would, if the discussion is about who controls the company, who has powers of control, then I suppose the reference would be to equity share capital in section 548. All right, so because equity share capital essentially focuses on the part of share capital that is not limited as regards capital or dividend in terms of distribution in assets of the company. So if you look at section 548, you would see that it basically defines equity share capital as that part of your capital that neither as respects dividend nor capital is limited. In other words, what they're basically saying is we're not including preference shares, right, who would be limited. So the real risk bearers of the company would be the ordinary shareholders. They don't have a cap on dividends. They don't have a cap on the return of capital. So hence, Section 548 focuses on this. And that's why I think here you'll see a reference. I put in a note that preference shares usually they're entitled to a fixed return by way of both dividends and capital. Obviously, it depends on how you would have designed it. And I think that was one of the points we talked about last time, that we should never assume, right? You have to look at the terms of issue to see precisely how it has been designed. But if it's the standard way, then it would fall. It would not be regarded as equity share capital. So now that and as I said, that kind of discussion is really a discussion about control, right? So when you want to sort of find out who are the controllers of the company, then people tend to use, technical people anyway, tend to use the term equity share capital. And then on the other hand, when we talk about the capital that has been allotted, so the capital that there is a contract between the company and a third party to allot, right? So the company may not have allotted it yet, but there is a contract. Then we refer to it as allotted share capital. And the moment you finalize the allotment by registration, i.e., the moment you move away from contract to property, right, then it becomes issued. And we talked about this the last time. So basically, the distinction between issued and allotted share capital is essentially a preservation of a distinction in English law between contract and property, right? And that's something that every sort of lawyer basically knows, that there's a difference between contract and property. But I noticed that in company law, people tend to use these terms interchangeably, right? Even the textbooks. So more or less, it doesn't really matter, but it's good to be aware of it. And sometimes you see people in practice making this mistake. There was a case that I was involved in where I think there was an SPA, a share purchase agreement, pursuant to which shares were to be issued to an investor. And after signing the share purchase agreement, but before completion, the issuer or a company had a change of mind and said, we're not doing it again. So the investor goes to court, or rather goes to arbitration. So they ask for specific performance. They also asked for conservatory measures to prevent the company from giving the shares to a third party. So conservatory measures would be your injunction, right? So it was an ICC case, so that's the terminology they use. Now, but if you're going to ask for conservatory measures, right? So if you're going to ask for an injunction, then it must be because you cannot be compensated in damages, right? I mean, the only reason why you would ask for an injunction is because damages will not be an adequate remedy, right? That's the standard. Now, but you can't really make that argument if you had no property. All that we had was a breach of contract, right? Somebody changed their minds and therefore breached the contract. All you can do is sue for breach of contract. You do not then say to the tribunal, I want you to stop this party from, in a sense, conveying the shares elsewhere, unless, of course, the shares are some kind of rare antique product, right? So if you're trying to buy some, rare painting, then you may say, this falls into a different category, and therefore I want the courts or tribunal to grant me that. So the reason I make this point is that sometimes people do not get this distinction right. And I remember once the lawyers on the other side in their writings kept on referring to it as our shares. And I kept on thinking, you don't have any shares because no shares have been issued. It is only when shares are issued, i.e. when there is a conveyance and there's registration, that is when you get property. Before then, there is no property. And that's what was said in at least in the National Westminster case. Now, I know we talked about some of this last time, but I just wanted to sort of refresh your memory. I then said the real thing that we need to focus on is this: legal capital. So notice when we talked about issued, called up, these are terms in the Companies Act, right? Issued, called up, allotted, down to equity, share capital. What we do not see in the Companies Act is legal capital. Previously, we used to have what they call authorized capital. I'm sure some of you come from jurisdictions where you have authorized capital, right? So basically, it's a ceiling. It really doesn't make any sense. You're basically saying, well, we aspire one day, right, to raise $1 billion or whatever. And so that's the ceiling, and it's called authorized. Of course, it misleads people. So people see it and say, oh, this company has a big capital base, but it's irrelevant. And actually, it could even be counterproductive. There was, I gave a paper at some conference some years ago, where, when you go to these international conferences, it forces you to grapple with other systems of company law. And I saw this system where the Corporate Affairs Commission, i.e. the Register of Companies, essentially had an ad valorem tax that basically taxed authorized capital. So basically, what it does is you pay more money to the Register of Companies the higher your authorized capital is, right? So it was an ad valorem, I call it an ad valorem tax. But basically they said, registration cost. Now, whether your capital is 1 million or 100 million, there is no greater effort in carrying out the administrative work, right? So you just carry it out once. It does not depend on the amount. And therefore, if you then stagger your so-called cost, the administrative cost, then essentially it's a tax. That's all you're doing, it's a tax. And if it's a tax, what nature of tax is it? It is a tax on aspiration. It's not a tax on profit. Nobody's made any profit. It's not even a tax on capital. It is simply an aspiration that, we have this authorized capital. One day we aspire to reach this limit. And maybe you don't. You raise your capital. And then, civilized systems will tax your profit, not your dreams. Right? And that really was a problem. Anyway, so we come back to legal capital. And I did make a song and dance about this the last time we met when I talked about how we measure it. The reason I do this is that you will notice that in virtually every corporate finance transaction you look at a problem-solving stage or transaction stage, wherever creditors' interests are implicated, right? So whether it's a reduction of capital, a demerger, a scheme of arrangement, debt equity swap, whichever way, so long as if you ever get to a point where creditors' interests are to be affected, then you want to be sure that your capital yardstick remains intact. In other words, the money that you should use should not you should not deplete it to such an extent that this figure goes down, right? So in other words, if called up capital, let's just put it this way, assuming called up capital is £1 million, right? So that's called up capital. And then because the capital was raised at a premium, there's an additional 500,000. So we say, undistributable reserves will be 500,000. Therefore, legal capital will be, called up capital, which is par multiplied by the number of shares in issue, plus undistributed reserves, i.e. 1.5 million. Now, it then means that if you want to do, let's say, a return of capital to shareholders, and the return of capital is, say, for 4 million, we want to be sure at the end of the day that you still have 1.5 in your treasury box, right? So you should not eat into that. That's a rough description of it. Obviously, when we begin to apply the law technically, you'll see that it's slightly more complicated than that. But I think intuitively it's important to understand this as functionally the role it plays. And that's why I say a distribution should not have the effect of reducing the company's net assets below legal capital. So if you're looking at the balance sheet, that's what you really should be looking at. Then the other thing we would be looking at as we go along would be the undistributable reserves. So far, we've talked about the share premium account, but there's also another undistributable reserve. We're not going to talk about it today, but later on we'll talk about it. It's called the capital redemption reserve. It's a reserve you have to create whenever you redeem shares. So if you're going to do a buyback of shares, when I talk about a buyback or redemption, essentially it's the same thing, right? It's the same thing in economic terms. So if you buy back shares or you redeem shares, the law basically requires you, if you cancel the shares, to transfer a notional amount to a fund. Not when I'm in fund, there's no money there. It's just an accounting adjustment to transfer a notional amount reflecting whatever you bought back and cancelled into this so-called capital redemption reserve, and that reserve is treated as an undistributable reserve. So if we were working with 1.5, we would need to look and find out whether there has been any of such activity, so that then increases. So it actually really calls for some real examination of the company's accounts before you advise on simple things like the payment of a dividend. And let me just make this clear: if I say a simple thing, a dividend, if you pay a dividend, if you advise directors to pay a dividend, and they do not have enough distributable reserves, then the directors will be liable to repay everything. So this is severe, right? Because directors are trustees. So if they misapply trust funds, then they would have a liability to account. So that liability is not small. It's big, right? So you certainly don't want to be the lawyer advising them incorrectly. Okay, and the other thing we'll do as we go on, not today. So yes, thank God I did flag that up. I said we're going to look into the whole idea of net realized profits. I'm just flagging it up now. It won't make any sense now, and I don't want to introduce it. But it's something that we will need to look at. And in fact, in a future seminar, when I look at it, I actually produce figures for us to work with so that we understand how the accounts will affect your calculation of profits. Now, thin capitalization and its legal consequences. Remember we said, companies are not under any obligation to have a minimum capital. Certainly a private company is not under any obligation to have a minimum capital. Public company, yes, there is, but they can lose the capital the next day, and there's no duty to replenish, right? So the point is that it's possible to be thinly capitalized. In other words, you sort of load a lot of debt in a company and use very little equity. So your rights of control obviously are secure, but by loading a lot of debt, you basically promote yourselves on the pecking order, right, to compete with other creditors. And in some cases, you take security, so you're even in a better position. And then from a tax position, because interest on debt is tax deductible, you put yourself in a better position, at least as far as the taxman is concerned. Now, the problem with this is that company law had always struggled with the idea of thin capitalization. Some judges said in the early days, if you look at FG Films, they basically thought that this was somehow wrong. And so FG Films said, well, this surely should be a ground for lifting the veil. But this is bad law. This is bad law. Nobody follows that, now. It cannot be a ground for piercing the veil. I mean, why? Why should it be a ground for piercing the veil? Parliament has basically said you can set up a company with 1 penny. So why should we then disregard the corporate veil? That's number one. Number two, we don't even go about lifting the veil anyway, right? Because, English law has a very robust principle of separate legal personality and the need to respect separate legal personality. So we don't do that. However, the reason I put it there is that if things go wrong in the company, say imagine a company goes into insolvent liquidation, there is possibly wrongful trading, so the liquidators bring an action under the Insolvency Act for wrongful trading, otherwise known as reckless trading, carried on by the directors, then the courts could say that, well, things were always bad with this company. Can you imagine? They started with a very low capital, right? They undercapitalized the company. So that's the context in which it could come up. But on its own, I don't think it's at all relevant to lifting the veil in the way FG Films put it. So as part of a mix, yes. So as part of a disqualification of directors when things go wrong in a company, yes. Wrongful trading, yes. Misfeasance, yes. But on its own, no. Okay. Then that's the tax implication, which I flagged up. Now, so the theoretical perspective on the rules of capital, which is what I asked you to look at, to sort of familiarize yourself with this in anticipation of this class today, is a way to make sense of a mass of boring rules, right? It's a way to make sense of a mass of boring rules. And essentially, the way I put it is to say that a company law has certain functions, right? So company law basically, discharges its functions through certain fundamental rules. So we have, rules on separate legal personality, right? And rules on limited liability, right? And we probably would have stopped there, but because we know separate legal personality has consequences for third parties, and limited liability also has consequences for third parties, there was a need to develop a whole series of rules to protect those third parties. So in the case of separate legal personality, you'd have rules on ultra vires, the abolition of ultra vires, the authority of directors not being affected by, or rather, transactions entered into by directors not being affected as far as the third party is concerned, so that the third party benefits from transactional security. Right? So we understand these rules. Every legal system basically would have it. They're usually in the Companies Act, and then at the tail end you have agency, right? So if you go to Tesco today and you buy something from Tesco, you don't need to look at the articles of Tesco. You're protected because of agency, because in a sense Tesco has held out the checkout boy or girl with ostensible authority by literally putting them in a uniform, and so you know that they have authority to deal with you. That's at the level of agency. If you go slightly up, then you're dealing with directors, right? And then, so common law basically deals with that. So I'm not concerned about that. But the point I'm trying to put across is that the law basically tries to deal with certain risks. So one is third-party risk, which flows from limited liability. And the other one is oppression. Oppression flows from the fact that we have a majority rule principle, right? So if you're going to set up a company and everybody is to take part in the company, you really cannot apply a rule of unanimity because it will just tear the company to pieces. You need some mechanism by which the will of the majority will bind the minority. Now, that itself leads to the risk of oppression. And the significance of that is that these two ideas, oppression and third-party risk, frame our understanding of capital. Many people don't talk about the oppression bit. They think about third-party risk. But I think the two are important. And in fact, last time we met, if my memory serves me well, somebody asked me, why do we have PAR? Why do we have PAR? And I said, how do we know there's equitable contribution? Remember? We had that discussion. How do we know there's equitable contribution? That if you take a share, you pay, for the share with a transfer of assets, the next person does exactly the same thing. We need a system to assure people of equitable contribution. Now, that very notion tackles oppression, right? It tackles the risk of the majority, right, having a differential payment system, which, by the way, we now can do, right, because you can change power now, right? But the point is that that's the idea. So, so here we're talking about third party and oppression, and I'm basically saying here that at the point where you're putting assets into the treasury, which is what we're going to be doing today, shareholders like to minimize the transfer of assets as much as possible. Right? Shareholders want to put in very little into the treasury. And then at the point where you take assets away from the treasury, shareholders want to maximize the payout and certainly do not want to wait for any other person. Now, creditors, on the other hand, want the opposite. Creditors want the shareholders to pay in a lot into the treasury. Left to creditors, they would want minimum capital rules. They would want a rule on capital adequacy that would apply to every company, right? So the creditor would want a well-funded debtor, capital adequacy rules basically requiring you to replenish capital whenever you lose capital. That's what they would want. And they would, on the other side, the creditors would also want to prohibit any return of value to the shareholders until every creditor has been paid. In other words, creditors would not want to, in a sense, take the risk of shareholders dipping into the corporate treasury. So what the law basically tries to do is to accommodate these two conflicting interests. And it accommodates them by a set of rules. And the rules are the rules on raising and the rules on return. So, for instance, when we talk about PAR multiplied by the number of shares in issue plus undistributable reserves, that is one way we're trying to control the extent of payouts from the corporate treasury. So take your minds back to the year before the share premium account was introduced. So the year before the share premium account was introduced, you could issue shares at a premium, capture the premium, and pay it back to the shareholders as profits, right? Because there was no obligation to set up a share premium account. You remember, we talked about this. Now, so if that were the case, clearly creditors were not happy with it. So what creditors, in effect, did was to lobby Parliament for a rewriting of the rules to capture this premium. Because the problem was, how do we define this premium? It's not capital, right? It's not capital. That's why they call it a share premium. And that's why we don't put it in share capital. We set up a reserve called the share premium account. So they basically convinced Parliament to say, you know, let's capture this premium. Let's not return the premium to the shareholders, and instead keep it in the company. So, and this is consistent with my idea that creditors are very interested in preventing payouts, right? So you prevent a payout when you capture the premium, right? Even if we struggle with how we characterize the premium. So, so there are 4 questions here that the law has to resolve. And these 4 questions should frame our approach to the law. And this way, the law becomes less boring. It becomes less boring. How much should shareholders pay into the corporate treasury? And what form should it take? How much should shareholders pay? And what form should it take? So by now, I'm sure we can guess this, that we now know that shareholders can pay in anything, no matter how low, right? Because there's no minimum capital paying requirement. Obviously, if it's a public company, right? If it's a public company, there's a minimum paying rule, right? Of effectively £12,500, right? Because you need to pay 1/4 of 50K. So, so to that extent, we'll say creditors have achieved something. And you may say, what have they really achieved? What's 12.5? You know, so essentially, anyway, as far as private companies are concerned, the rules are light touch. This is what we're seeing here. So when we ask this question, how much should shareholders pay into the corporate treasury? The law basically says, well, the answer to this question really depends on whether it's a private or public company. If it's a private company, then they don't need to pay in anything. all it needs to be is just a fixed amount. It doesn't even need to be legal tender. A fixed amount can be less than 1 penny, right? So they don't need to pay in, any minimum figure, so long as it's a fixed amount. And but if it's a public company, because we think creditors' interests will be more engaged there, we would want a pay-in requirement of some sort. And we also know that there are many ways payments can be made. We need to regulate that, and that's what we're going to be dealing with today. And what form should it take? Should it take the form of cash or non-cash? Bearing in mind that the example I gave the other time, I write a business plan on half a page of A4, and then I sit down and say, well, I think that's worth 20K. There is always a risk of the company receiving assets of illusory value and then issuing shares. So how do we do it? How do we regulate this? Again, you'll notice that the law makes a distinction between public and private companies. Private companies, you can do whatever you want to do. An idea which goes way back to Solomon's case. I remember I gave you the quote the last time where the House of Lords, in talking about the transfer of Solomon's business in Whitechapel to his company and the value he put on it, described it as the fond expectations of a sanguine owner or something like that. And then how much of the assets can be paid out of the Treasury into the pockets of contributories? Right? How much of the assets can be paid out? So left to creditors, they would rather you don't do this, right? In fact, they would have a rule. Left to creditors, they would say, you only pay out when we want to liquidate the company, right? So there'll be a rule on liquidations, right? But never pay out until we get to that point. But obviously, shareholders are not going to want to wait till every creditor has been paid. Shareholders want to receive something because at the end of the day, they're involved in the same businesses as creditors. So shareholders would say, we really want to get something. So the question then is, how do we determine what they can get? We go back to the rules on legal capital. We say, well, you can get something out of the company so long as you keep the capital yardstick, so long as legal capital is not touched, right? So that you see, and whichever form it takes. So assuming you were doing a share buyback, right? If you're doing a share buyback, we would still have to ask that question. And the way we ask the question is, are you financing the share buyback through your distributable profits? If the answer is yes, you've already answered the question. Because for you to say the profits are distributable, notice you didn't just say profits. You said distributable profits. It means you've taken account of the capital yardstick. And that would be fine. And then when do we do this? Is it a liquidation? Do we wait for liquidation? Clearly not. We want to do this before, and under what circumstances? Right? Notice here also, the law also seeks to ensure that there is equitable contribution among shareholders. Right? Through the concept of par and directors' duties. Sorry. So through the concept of par and directors' duties. So where does this come in? I mean, so you may have a situation, let's say, in practice or problem question, whichever way, where let's imagine the share price of a company is, let's say, £10, and par is £1. And the directors decide to issue shares at £1.50. Right? So par is £1. Market value £10. The directors issue shares at £1.50. Is that fine? What do you think about that?
Shareholders probably wouldn't be happy.
Yes, yes. Good point.
What about the duties of the director is to the shareholders as well?
Yes. Well, a duty owed to the company to take account of their interests. No, I'm happy with the answer you gave, because the common denominator is that you didn't go to rules on capital. You knew that there was no infringement of capital rules, right? You never said, oh, this infringes par, right? Because it did not. They issued it for £1.50, and the par value was £1, right? So the rules on capital at that point do not apply, but it does not mean we do not talk about directors' duties. So the question would be, why are the directors, right, issuing the share at £1.50 if they could issue it for £10? Now, ultimately, it will depend on the reasons they give. Right? So we're not going to be too quick to penalize them. We're going to be asking, what was the business judgment? Bearing in mind, the courts will always respect business judgment. So if they say that, we're about to enter into some strategic alliance with this company, then it begins to make sense, right? If, on the other hand, they're issuing it to their families, right, then, alarm bells begin to ring, right? So that's, one way that could come up. Now, so bearing in mind this, I now say that we're going to build on this theoretical framework by focusing on the rules, on the capital raising side, and we're basically going to look at two things: to examine the rules on the raising of capital, how they achieve this reconciliation, this, is it a partial reconciliation, I suppose, of these adverse interests. And then the second one is to examine how company law regulates the equity component of capital structure. And what do I mean there? So if you look at capital structure, the relationship between debt and equity, because it touches on the question we just talked about now, right? When you said the shareholders will not be happy. So capital structure is a relationship between debt and equity. And if the directors of the company decide to increase equity, then in a sense, the question arises, how do we regulate them? Who controls capital structure, especially the equity side? Who controls them? So that really deals with the question, do you have the right to issue the shares, and at what price? Right? Because when you said the shareholders will not be happy, the answer really to that would be to say that shareholders should have the power of allotment, right? So the shareholders should be able to authorize directors, right? So the directors need to get the power from them before they issue shares. That's one way. Secondly, the shareholders should have preemption rights, right? And then thirdly, there should be market structures to support this. And that's what we have in the UK. And interestingly, not all legal systems have this. So there are many legal systems where the shareholders really don't have a say, because the directors have the right to issue shares. After all, they're the ones managing the company. They know what is best for the company. There are also cases where the shareholders do not have preemption rights, like in America, right? It's not always guaranteed that you have preemption rights. And then thirdly, they don't have market institutions that support this. And there is empirical work that demonstrates that when managers issue shares without these three things in place, the share price tends to fall. Whereas in jurisdictions where you have these three things, when they issue shares, the share price tends to go up. What do you think is going on? The market knows that there is a potential agency cost here, right? You're taking directors who are rational people and therefore are going to be minded to protect their own interests, right? And you don't have any kind of controls. So the market basically devalues things because it takes the view that these guys are now about to expropriate the company. And that's why you see the share price go down. Whereas it goes up when you do it correctly. And I'll show you, I'll just quickly allude to this. What I did was to, under the topic control of capital structure, I then make a connection. So let me just quickly deal with this here. Sorry if I'm jumping, but I just thought it's better to deal with this. So here I said ultimately capital structure decisions, regardless of the legal rule on who decides, ultimately driven by commercial considerations. And you see this a lot in, sort of private equity transactions and all that. So it's really commercially who has more power and all that. How much do you need of money, right? And I kind of discussed this here. But I then say that, not surprisingly, the negotiation of preemption rights for managers tends to be a key in these transactions. Then I say capital structure decisions are driven by tax reasons, right, which I had kind of flagged up. Then I say here, so this is the key bit, that the right to determine capital structure is ultimately vested in shareholders. And there are two aspects to this. So there's the debt aspect and the equity aspect. Right, so the shareholders can put in a clause in the articles to say, we don't want you to borrow, right, or to borrow beyond a certain amount, so that deals with debt. Likewise, with the equity aspect, the shareholders don't even need to write it into their agreement because the law protects them, right? So if you look at, I'll skip this paper and quickly look at how the law does it. So, shareholder control of the company's power of allotment exercised by directors. So, if you look at section 549 to 551, you see that it basically gives our shareholders the control of the power. So, the directors cannot do it without authorization from shareholders. In practice, what tends to happen is that as a housekeeping exercise, the directors in most big companies will always ask shareholders for routine authorizations, right? Which they can warehouse and then use as and when. But this is where the market structures kick in. Because if you try to abuse the warehousing arrangement, then you have, institutional players in the market, and I'll talk about them in a minute, who basically would say this will not fly. So that's the third layer. So the second layer of control will be preemptive rights. Right? So shareholders have a right of preemption when there's an allotment of equity securities. Right? Notice it talks about equity securities because that's where control is. Remember we talked about the definition of equity securities the last time, section 547, where we're looking at how you define it, right? So we're not interested in preference shares. There's no control. It's like debt. This is where control is. So this is why we need to be, we need to look at preemption rights. And guess what? Creative people find ways around preemptive rights, and we're going to be talking about them. So, for instance, you could, because there's the law does not protect preemptive rights when the allotment is for a non-cash consideration. So, what people tend to do is use what they call cash box transactions, whereby you use a non-cash. You basically allot the shares to an intermediary, right? and the consideration will be non-cash, and then you then finalize it by the intermediary, then passing the shares to whoever you want to pass it. Meanwhile, you've basically bypassed the shareholders. So again, how do we deal with this? The market system I just talked about will kick in, right? And I just want to flag this up here. Market control. So here we have the IMA guidelines on share capital management. So that's the Investment Management Association. They're big players in the market, and then you have what they call the preemption group principles, right? And basically, if you're a player in the city, if you're a CEO, you do not want to infringe these rules, right? Because it just means you'll be blacklisted. So to really understand the rules on capital structure, you need to know not just the legal rules, but you need to know how the legal rules work with these market control mechanisms. And of course, when we were talking before, we talked about, remember when I posed the question, you said, well, the shareholders will not be happy, and the way we formulated that discussion was in the context of directors' duties. Remember, and I talked about this. I talked about the subject of good faith. The business judgment rule. Those ideas would be the sort of ideas you want to explore under 3 and 4, right? So in other words, if I were to issue shares at below the market price by a substantial margin, the standard company law response would be that, well, have you complied with your duty in Hilda and Dexter? Which basically says that you have to apply your powers in good faith for a proper purpose, right? And consider the affairs of the company, subject to the business judgment rule, which is what we were talking about. And Section 171, have you done it for a proper purpose and not an improper purpose? Did you do it to your family? Or is it because you guys had a strategic plan you were going to go into with another business, right? Those are the common law questions. But then the wider questions actually would be, one, do you even have the power? All right? Do you even have the power of to allot the shares? Have the shareholders given you the power? 2, if the shareholders have given you the power, how come you bypassed our preemption rights? Because we have statutory preemption rights. Right? And if the company is a listed company, then the preemption guidelines will also kick in. Right? So that's how it basically works. Now, just one point I thought to mention here. Remember I said earlier that in jurisdictions where you do not have these 3 layers of control, no shareholder authorization, no preemption rights, no market structures, empirical evidence does suggest that when you issue shares, you issue shares in the market, the companies suffer a diminution in value, right? So when you look at the share price following the announcement, it drops, and that's what this paper basically does. Explain, and the paper then goes on to talk about the different systems of control, and I just want, because what I've just done here is to kind of summarize it, and so the key finding here is this: when shareholders approve an equity issuance, the average announcement effect is positive. So that's when shareholders approve. Not all jurisdictions have shareholder approval. In contrast, when managers unilaterally issue stock, the average announcement effect is negative. In aggregate, these findings suggest that agency conflicts affect equity issuances by public corporations, right? So that basically there's an agency problem going on. Now look at the position of the United States here. In the United States and a few, so these are quotations from the paper, and a few other countries, management typically needs only board of director approval to issue common stock. In the UK, we need more than that. You need shareholder approval. You have preemption rights. But in most countries, by law or stock exchange rules, shareholders must approve equity issuances undertaken by a certain method, right? And usually the methods would be the methods I've just talked about. So that's an interesting one. And then if you look further down, you see that the writer then tries to class the various companies, the various countries into different classes, and there was a slight methodology problem. Well, not problem, but I think he dealt with it. My view initially when I was reading it was, you can't make a determination about class if you did not look at market controls, right? So you can't just look at the law and ignore market controls, which, by the way, he did. He looked at market controls, and I thought, okay, that's robust, because when you understand how the market works, you'll see that the preemption guidelines, the IMA guidelines, are very effective. And then also here he talks about types of shareholder control. So he says the first approach is to require that shareholders vote to approve all equity issuances. And then the second approach is to require shareholders vote to approve only equity issuances that are not offered to them. So these are called, preemption rights. Right? And then the final one is to allow managers issue equity with only board of director approval. So you see, there are these three possibilities, and the UK clearly is 1 and 2 plus the market. Right? 1, 2, and the market. So and then here, look, under UK law, shareholders may waive their preemption rights for 5 years. Right? In fact, not only can you warehouse authorizations, right? So the board goes to meet the shareholders and say, "Oh, please, give us your authorization." They also get them to waive preemption rights, because shareholders are stupid, and do that, right? And my point earlier was that what really controls things are the market structures. And so when I was reading the paper, I was wondering, how would he class the UK? Because if you look at those practices, right, then you could class the UK, and you could apply a not very favorable classification to the UK, but he didn't. He says, this would suggest public offerings in the UK should be classified as 2. Then he says, in practice, the issuance process in the UK is structured around the more restrictive provisions on preemption contained in the preemption group. These guidelines specify that shareholders should waive preemption rights and sell stock for no more than 5%. And it goes on, right? So you can see how robust it is. So I know I sort of jumped, but I thought I needed to sort of quickly, because that was, it fell within a narrow compass, and I thought I could deal with it. Yes?
So are there any limitations on your statutory preemption right, in the sense of, does it apply in relation to the allotment of preference shares, or is it just for...
No. So it doesn't. You don't get, your preemption rights would only apply for equity securities. And let me just show you here. And remember, remember I said equity securities is about control. And preemption rights are about preserving my right of control, isn't it? Not the creditors, not preference shareholders who are flitting. All the preference shareholders have is a coupon, right? A high coupon.
Even if they have a right to participate in the surplus, but they still not.
Yeah, so that then takes us to what, I'm happy you raised this, what constitutes equity securities? Because we can't just look at a preference share and say, oh, that's not an equity security. We would need to look at the rights. Do you see? So, thanks for raising this, because remember when I said to you earlier that don't go by the description, look at the rights. That's really what I had in mind. And also when I talked about equity securities, I said you need to look at the rights. Has there been a cap on capital, on income, right? And then I said, when you look at the definition in 547, it's really about control. So it then depends on the context in which you apply it. So, and you've just come up with this context. So assuming we want to issue shares, and we're basically saying, there are no preemption rights applicable for this class of shares. If the preference shareholders believe that their preference shares have been configured to look like equity, then they're going to resist it. So here I say Section 561 confers on shareholders the right of preemption where there is an allotment of equity securities. And and again, so you see the definition of equity securities, and then in terms of bypassing preemption rights, the two ways that we could do this. One could be to use in fact, I raised this here in the context of the CAC case, and then the non-cash consideration. So you choose to issue the shares for a non-cash consideration. You would bypass preemption rights, right? And so in practice, in the city, what tends to happen is they have these box transactions, right? So they dress up the transaction in such a way that the company is issuing the shares not for cash, but for a non-cash consideration, only to do what they really want to do later on, right? And they've gotten away scot-free. So the only sort of measure of control tends to be the preemption guidelines. And that's why, again, if you look here, I'd like you to just reflect on this, that corporate finance law has a strong soft law component. I mean, I don't know if that's, if that's contradictory, but you get the point I'm making. Corporate finance has a strong soft law component. In other words, it's not just about the law. We need to look at these standards, right? We need to look at these standards. And this applies generally. I'll give you an idea. I was an arbitrator in some LCI dispute, and there was to be I think the respondent asked for security for cost. So security for cost is, the idea basically is, I believe the claimant is so poor that if I win this case, he will not be able to pay my costs, right? But tactically, you're really trying to squeeze them out. And in this case, the company which was applying for security for cost was Shell Trading, was one of the Shell subsidiaries. So in order for the arbitrators to decide whether to grant security for cost, we needed to look at the balance sheet of the company. So if we're looking at the balance sheet of the company, what do you think we need to focus on? Sorry? So this is practical. I mean, so I get the, yeah, okay, sorry. What can be, okay, okay, and I mean, I can imagine the company would be saying that, all right, to say, you know, we have some money. You know, we could pay a dividend tomorrow with this money. So the company would do that. Indeed, that's what they did. But we went a stage further to say that how much was your cash flow? All right? So we're basically looking at net assets minus your net liabilities, your current liabilities, right? We're trying to work out how much cash you have. And in doing that, you then discover that there's soft law. So, because the accounts are prepared using IFRS standards, and it tells us to look carefully at the notes to accounts. So, on the cash and cash equivalents, which is supposed to be the freest money, right? Cash and cash equivalents is the freest. You can take the money out. Then you discover a small note in the accounts that seems to contradict the very notion that this is cash easily realizable. Because they put in a note to the effect that, well, there is an agreement in regard to cash and cash equivalents. It's kind of ambiguous, but we know that there's no free disposal, right? And that then means that the company actually does not have much. Do you see? So the reason I mention this is that it's important to look at the soft law in whatever jurisdiction you're talking about, right? Because every system will have its soft law. So in this case, we're looking at IFRS standards, notes to accounts, just to work this out. Here, we'll be looking at these statements. So that's why I said consider how market regulates dilutions, right? Because that's what we're talking about, a dilution. How does the market regulate it? So I'm not interested here in how the law regulates it, right? Because I know it's very easy to quote the law. We're not interested in how the law regulates it, but how the market regulates it. And I think that's the idea.
Can I just ask two more
Yeah,
questions?
please.
Would convertible preference shares fall within equity securities? The equity securities definition of that?
So convertible preference shares. Now, because they have not been converted, right? You look at their nature by reference to their pre-conversion nature. So it would really, I mean, in that kind of situation, if you have convertible preference shares and you have, you literally have a put option to convert it immediately, that's what you'll do, so that it becomes equity. But if you don't have the power, if the power to convert is on the other side, then how can that be equity securities? Do you see? Because the other party, right? So maybe the company, and when the company designed it, basically the company basically has the right of conversion, right? So at the end of the day, all you just have is a preference share, and you're hoping that one day, maybe this company will just change its mind and make you an equity person. Oh, sorry, the company hasn't.
And the non-cash consideration, how does that work in relation to the par value requirement?
Well, that won't be a problem because you will state. Actually, there's a slight problem there. You will simply state the par value, right? But because you will be issuing the shares most likely at above par, there will be the need to set up a share premium account, which by the way, in many of these cases where you transfer assets, people never thought about it that way. They always thought we set up a share premium account when it's cash. So I buy a share, I give you £2, and the par value of the share is 50p. I understand I have to put 150 in the share premium account. But what if what I'm transferring is an asset? Because the consequence of this is that, especially in the takeover scenario, where if you swap your shares, so you do a share exchange, and your shares are above the value of the target, then technically it means you have to set up a share premium account, which then affects the distributability of the profits of the target company. So money which you wanted to distribute when you took over the company, suddenly you discover that I cannot distribute it because of this obligation to set up a share premium account. I mean, there are ways around it to solve that particular problem. But yeah. Okay.
Can I ask a question to the first one?
Yes. I've forgotten the first one. Which one's the first one?
With the convertible preference.
Okay, yeah.
So how are the existing shareholders protected? Is it when they exercise their right to convert, or do they just not have a protection? Okay.
Well, it depends on the right. I mean, obviously, if the right is on the other side, then you really do not. You have a right that is contingent on what the other person wants. That's, so in a sense, what kind of right is that? I mean, you can't, because it's contingent on the other side. Obviously, if the right is vested in you, right, and in terms of conversion, you're in the money in terms of the exercise price, then the law generally would protect that. And we see this even in takeovers. I remember in one of my classes we were talking about the whole idea. Under the takeover code, we have what we call Rule 16, which basically says that you should make a comparable offer for other classes of contingent equity, right? So it looks at the nature of that security, that it is contingent, but not contingent in this first sense, but in the sense which I've just talked about. Okay, so now, maybe we should take a break. I forgot. We should take a break. And okay, we'll take a break. Sorry about this. I just completely forgot. So many interesting questions. So 10 minutes, huh? We're going to start the boring bits now.
Yeah, that was a good time.
I'm not sure.
even now, like, some of them, because if you don't very good
So now, if we just look at the rules, we have general rules which apply to all companies. So every company should have a par value. The shares should have a par value. That applies to everyone. And for every company, if you're going to issue shares, you should never issue the shares at a discount to the par value, right? So regardless, so even if the company, as you would have discovered, or as you would see in the Oregon gold mining case, where the company's share price had fallen below par, right? And the company needed to be rescued. So somebody was going to invest money. So the question was, how do I pay for the shares? I mean, if I buy the shares on the market, right, it's below par. So why should I pay, par when I buy shares from the company when I can get it cheaper? And this was a case that the courts had to deal with in 1892 when the rules were just. In fact, we didn't have these rules. We just had limited liability, and you see the courts basically establishing why that company had to fail so that many will survive, right? In the sense that, we need this rule, and even if the consequence is that you fail, right? And I'll talk about that. So the prohibition of an allotment at a discount is important. And so you'll notice again that if you want to give people shares as part of a corporate finance transaction, so imagine a situation, say, in America, you want to issue poison pills and give it to them through shares, or you want to, in the UK, you want to return value to shareholders, right? So you're doing a return of value to shareholders, and you say, okay, the way we're going to do it is to return the value through shares, i.e. we give them shares which we can redeem, right? So the shares end after redemption. Now, but the problem is the shareholders have to pay for the shares because the law says you've got to pay for the shares. So the question then is, how do you go around this, right? Because you have a mandatory norm that you've got to pay for shares, A, and B, you should not pay at a discount. So the way you do this would be to we'll talk about this later, but basically the way you do it would be to issue what they call bonus shares, which is simply a capitalization of reserves. So you take the share premium account, right? If there's a lot of money in the share premium account, let me make it simple. So share capital account, 1 million. The company had issued shares above par, so there was actually 2 million on the share premium account. So now we know legal capital would be you add 1 plus 2, right? I used 1 before, right? Plus 2, 3. Now, my point basically is that why didn't we put the 2 in share premium account into share capital? We didn't because the law in 610 says set up a share premium account. The law took that position because the law knows that the premium is not capital. Capital is par, right? So because we understand this, that capital is par, but we don't want the shareholders to distribute the money. So what did we do? We looked for a sort of halfway house to say, put it somewhere where we would treat it like capital, even though it's not capital. So that's why it's in the share premium account. Now, if you then decide to move it from the share premium account to the capital account, then what happens? Your share premium goes to 0. Your share capital account, right, goes up. So if it was 1 million before and you've capitalized 2 million, it goes to 3 million, right? There's no problem with that because actually it's now protected, isn't it? It was protected before, but it's not protected as share capital. Now, if you do that, then we need to give you some pieces of paper to evidence what has happened. Because when you took paper in the company, you took paper for £1 million, right? Remember, when you put in money, 1 million, you got your whichever money you put, you got paper representing 1 million. The excess cash contribution went to your share premium account, right? But there's no paper for that. So you only have one piece of paper in your hands. Now that we've capitalized it, right, we need to give you additional pieces of paper to evidence this, right, to make you feel good. We call it a bonus share. That's it, it's a bonus share. So if you then do that, if you capitalize it that way, you can use this as a tool of corporate engineering. Because if you wanted to return value to the shareholders, you could use the share premium account, right, to give them bonus shares, right, which you would then use to stream money into their pockets later on. And by giving them bonus shares, they do not have to pay for it. So you don't need to deal with this rule, which says that, there's a prohibition of an allotment at a discount, or rules on payment. Okay, so far we've dealt with two rules: nominal value, and there should be no allotment at a discount, right? Then if you look at the Oregum gold mining case, which is the case I mentioned here, so basically here you see the court basically saying that, you see what the court is doing. It's tying it to limited liability. It says, it makes one of the conditions of the limitation of liability that the articles or memorandum shall contain the amount of capital with which the company proposes to be registered. All right, so you're going to get limited liability, but you clearly have promised to bring capital, right? It seems to me that a system created by which the shareholders' liability is to be limited by the amount unpaid on the shares renders it impossible for the company to depart from this requirement, right? So you cannot then unilaterally say, oh, you know what, even though I was meant to give you money before, I will no longer give you. Or even though I was meant to give you £1, I'll just give you 50p and treat it as £1. You can't do that, right? Because you basically have entered into this arrangement. So you see again where the judge says that the shareholders can't even change it. It says the agreement is one which the company itself has no authority to alter or qualify. In other words, there can be no ratification here. The shareholders cannot do this. So I then say, what are the key insights? I said the first paragraph suggests the mandatory nature of this norm that is being established without any kind of explicit statutory authorization. All he's working from is first principles, limited liability. In the second paragraph, we see that he does seem to suggest the presence of an understanding between shareholders and creditors. The understanding is that shareholders shall raise a certain amount of capital, right? And your liability is to be limited to that amount. And then we see in the third paragraph that this understanding of creditors is captured very clearly by regarding the capital fund as security for the creditor. And then we see the last bit where he's saying that the unanimity rule cannot apply, right? Okay, so, and then I then sort of test this to say, imagine a company has a horrendous amount of ordinary shares in issue, and the par value is 0.1, so not even up to 1p. And its share price is even less than that. Assume it is contractually obliged or obligated to allot ordinary shares to a shareholder at the current market price. Then I said, can the allotment be effected? Now this, by the way, these figures came from a transaction, I think it was last year. This was the problem they had, right? So I didn't change anything, I just put the figures there. So essentially, the company had these shares in issue, par value 0.1, share price, right, even much lower, and it had entered into an agreement to allot ordinary shares to the shareholders at the current market price. And by doing that, it would have been allotting the shares at below par, right? So here, the obligation, the contract cannot trump the statutory thing, the statutory rule. So the question then is, what do we do, right? What do we do about this? Do we simply say, well, you can't do it? No. In the next class, I'll show you what to do, but basically, we can reorganize the capital, right? So we'll reorganize the capital by doing a subdivision and consolidation to basically solve this problem, right? So, and that's why I just sort of flagged this up. And then, mostly in Covington Mines deals with a scenario where the company issues a debenture, and the debenture has a par value. So imagine the par value of the debenture is £1, and you issue the debenture at a discount, 50p. Is there a problem there? There's no problem, right? Is that a problem? No problem, okay, because it's a debenture, it's not a share. But the debenture is immediately convertible into shares with a par value of £1. You can see the problem, right? Because you, sorry? Yeah, well, yeah. So that's really the question. Are you infringing the rules? I mean, if you look at this case, you'll see that the judges took two different views. I mean, in the end, they concluded that they were infringing. But you could see that they were also saying if you read Cousins Hardy's judgment, that a lot really depends on the nature of the conversion, right? A lot depends on the nature of the conversion, right? So where it is pretty clear that it's to be immediately convertible, then you're simply trying to drive coach and horses through the statute, right? So take time and read this, and if you notice, again, I say issues to think about. Law Justice Von Williams described the case as borderline. Cousins Hardy says, in effect, never say never. Why? And that's the point I just mentioned. It really depends on the terms of conversion. But in this case, they came to a conclusion that what had happened was wrong. Right? Okay. And then, so now we know about Section 610, the treatment of issue of shares at a premium. That if you issue shares above par, you set up a share premium account, right? And you know that we didn't say put it in share capital because it's not capital, right? So that's why I put it in the share premium. So now, what then happens when I put in money into the company and I do not take shares? So I put in money into the company and I do not take shares. There are a number of possibilities. Presumably you could say I'm making a loan to the company, right? Certainly if the liquidator comes in, that's what I'll be saying, and the liquidator presumably is saying, well, show me the contract, what are the terms of this loan? The other argument would be that it is a contribution to capital, right? It's a contribution to capital. And if it's a contribution to capital, it then means that it has to be protected. But can we not say that it is simply a contribution to profit? right? In other words, it's not capital, it's profit, and therefore it's distributable. So which one would you go for? Which interpretation would you go for? Because in a sense, you're saying we've enhanced the value, right, of the company with this pay-in, and since I did not take shares, that is indicative of a desire on my part not to contribute it as capital. So in effect, what I've just done is create a profit, right? And that would mean we will be able to distribute it. But if you go down the other route, you would have to protect it like capital. Now, sorry, yeah.
So in this case, what's the legal relationship between this investor and the company? Because
Yeah, so he's a shareholder.
but he don't have any shares.
No. So he's a shareholder in existence. So I'm using the case of Keller and Williams, where so basically a capital contribution made by a shareholder, where he was not subscribing for shares, right? So he was not asking for shares. Neither was he making a gift to the company. The court basically says we're going to treat it like a share premium. In other words, what the court is saying is we're going to protect it. We're going to protect it, right? So they didn't call it capital, right? Because it wasn't subscription money. So, but they said we will treat it the way we treat a share premium, i.e., we'll protect it. Later on, I'll share with you a document issued by the Urgent Task Force of the Institute of Chartered Accountants on the question of what constitutes a realized profit, where they define gains. You will see that the definition of gains flies in the face of this case, because this case is saying treat it as capital. The accountants are saying treat it as a realized profit, right? We'll come to that, right?
If you treat it as a share premium, what can you actually do with it?
Well, if it's a share premium, then remember the share premium has to be protected. Remember, the only thing we did with the share premium earlier was that we capitalized it. We moved it from the share premium to the capital account, right? Where it's even more, that then it's full capital, isn't it? And I mean, we'll talk about the use of share premium account, but basically it's a protected fund. That's why it's an undistributable reserve. Although in practice, we tend to use share premiums to do a lot of corporate engineering, right? Okay, and then very quickly, you have the Section 552 prohibition, which basically says that commissions are not permitted, so you can't sort of pay for shares and then you get a commission. However, bear in mind that underwriting commissions are allowed. So one way we always test this is to use underwriting commissions, and then sometimes people kind of get it wrong. And then here, shares may be paid up in money or money's worth. That's the fundamental rule. Remember, we're talking about rules which apply to all companies. Shares may be paid for in money or money's worth. And the idea basically, so the only share you don't pay for in money or money's worth is the bonus share. And that's why we use it as a tool of corporate engineering, right? Because technically, you don't pay for it. So if you look at the EIC case, you'll see here, you see what the judge said, that he says, it's convenient at this point to refer briefly to the nature of a bonus issue. The essence is that profits and other reserves, so reserves, are capitalized. You move the reserves into your capital account, your called-up share capital account, and applied in paying up on issued shares. That's the paper that people get, right? So you're basically saying, oh, you've paid for shares, come and get your bonus shares. right? And he says the effect is that in contrast to a dividend which reduces the assets of a company, a bonus issue does not reduce those assets. It is simply a rearrangement of reserves, right? Okay. Then the other bit is that shares can be denominated in any currency. So the big problem, though, arises from the fact that shares can be paid for in money's worth. Now, this is where we apply a different rule to public companies. So in regard to public companies, we say, well, if you're going to use money's worth, if you're going to bring a cow as your payment, then, don't give that cow salt water and make it full. We will get an independent valuer to value it. If you say you're going to, pay for your shares without your business plan because you think you're Steve Jobs, we will get an independent valuer to value it, right? So that's what the law does in regards to the non-cash aspect. I'll need to finish because I'm just looking at time. So here I say in regard to this that the law's response to this problem, again, if it's a private company, we'll just leave it to the common law. Remember the Solomon example. It really has to be colorable, using the Victorian language they used. It has to be illusory, colorable, before the courts get involved. But by and large, you're safe. But if it's a public company, every non-cash asset has to be independently valued by a valuer, right? On the section 593. And then, so this is the Keller case. And here I ask you, what are the various possible treatments of such a capital contribution, right? And we kind of went over that. Now, in regard to the public company rules, you'll just see that they're pretty straightforward, and I'm not going to repeat them. I just want to flag up one thing. So it says, I'll flag up just one point which I think is important. It is this. An undertaking which is to be performed more than 5 years after the date of the allotment is banned as consideration for the allotment of shares. People always apply this rule wrongly. So we test it this way. Somebody says, well, I will give you on an undertaking to pay for my shares at some point in the future. All right, maybe 6 years later. And then what tends to happen is that people then say, well, that infringes Section 587. No, it does not. That technically is already payment, because an undertaking to pay cash in the future is payment in cash. So you've already paid. Whereas 587, right, is different. It deals with an undertaking, which is to be performed more than 5 years. So that's something I think you need to bear in mind, that the definition of cash is just something, I'd like to focus on. So we'll stop here. When next you come, I'll continue. And then we'll also use a number of problem scenarios to test some of these things. All right?
So, apart from the premium account, the par value goes into equity share account. Is this right?
Sorry?
The par value of the money goes into the
share capital.
Share capital account.
Yeah.
Share capital account.
Yes.
Okay.
Yeah. That's where. So you have the called up share capital, right? Called up capital. So you know when you called up capital.
Called up capital.
It's called up.
Yes. That's the called up capital means share capital account.
Yeah. So okay. Let me put it this way. So the called up capital, right?
Yes.
Would be capital proper. So if I issue a share If I issue a share,
£2.
£2, par value £1.
£1.
Capital is £1.
Yes.
Right? So £1 goes to called up. Right?
No,
Then
gotcha.
the other £1
Goes
goes
to
to the
share
premium account,
account.
which is an undistributable reserve.
Yes.
And which we treat like capital.
Okay,
right?
I see.
Yeah.
Okay. Another question is this refers to the involves the exam. This course, this module is an open book exam.
Yeah.
So what can we take?
Everything.
So including this.
Yeah.
Okay.
Yeah.
So.
I think yeah.
So question is refers to material.
There are two books. One is this one. The other is which one is better?
I did say they're both all right, right? They're both all right. I would say I should go for this.
Okay. How about a book from library?
Yeah.
Thank you.
Okay.
你去听吗？你还可以补一下啊。因为明天下午有一个旁听课，我去听听那个行长。